afternoon, everybody. I'm right. I'm a 1 o'clock girl. Yeah. It just turned 1 o'clock, so I like to start on time. So anyway, welcome to the meeting number 20 of the Standing Committee on the Status of Women. I know that many are online and some people are just getting online right now, but we do have a very important day and time is tight. So pursuant to Standing Order of Reference on Friday, April 29th of 2022, the committee will begin its clause-by-clause study of Bill C-233, an act to amend the Criminal Code and Judges Act, Violence Against Intimate Partner. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefits of our witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice, and at the bottom of the screen you will find floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. Before we begin, I would like to welcome the Department of Justice officials who are here. And will be discussing Bill C-233 with us. Shannon Davis, Irmouth, from Senior Counsel, Criminal Law and Policy Section for Policy Sector. Claire Farid, Director and General Counsel, Family and Children's Law Team, Policy Sector. Melissa Moore, Counsel, Judicial Affairs Section, Public Law and Legislative Services. So we will be proceeding, but for some reason, Philippe, you are not on my introductions, but I am sitting beside the legislative clerk, Philippe, who will keep this all in order and assist me with this if we have questions. I know that because these were all confidential, there are some amendments that you may have questions on. So you may want to ask one of the legal professionals on this so that we can have a better understanding. I don't believe there's many lawyers in the rooms. I think we're just all advocates for women and women's health. So we are going to proceed with clause by clause. And I'm going to move now to the agenda for clause by clause, which is right under here. So when I sing, that means I'm just changing the path of where I'm going. Do we have all of our members? I see Michelle on there and Shelby's on there. Fantastic. Is Mark Saray here today?
No, I'm requesting.
Oh, you're Mark? Hi, Mark. I just want to make sure we have everybody here today, so this is fantastic, and welcome to Mike Morris as well. So we're going to start with this. We're going to be going clause by clause. I'm going to be honest, this is my first time of doing clause by clause, so I will be turning my head a lot to the clerk, to the legislative clerk, just to ensure that we're getting this piece of legislation right. So we're going to start clause 1, NDP 1. I'm going to pass that over to Leah Gazan to introduce NDP 1.
Okay. Subsection 1.1, Section 15 of the Act is amended by adding the following after subsection 4.21. If the Attorney General requests that an accused who is charged with an offense against their intimate partner wear an electronic monitoring device, the Attorney General must take all reasonable measures to ensure that a device is available that makes the monitoring possible regardless of the geographic area in which the accused has been directed to remain, and B, if the accused were to approach any place where any victim, witness, or other person identified in order to make under Section 2 might reasonably be found, emergency services would be available to provide any necessary assistance to that person.
Okay, thank you very much. So what we can do now is discuss that. If there's some background or that you want to provide, Leah, on the reasoning for this amendment, what you think we should do, and then we can open discussion to this, and then we'll move forward. Leah, would you like to provide any?
Sure. So I think, in the committee meetings around this bill, one of the criticisms that was raised was actually access to this specific resource, meaning the electronic monitoring device, and issues around even if a person is able to have an electronic device, are there the appropriate supports in place to ensure that that individual is safe? So those are the purposes for the amendment.
I'm just going to do a speakers list. So if you are online, just put up your hand on the little, the little thing. And Pam, I'll see you in the room. Pam?
Thank you, and I actually want to start by acknowledging our chair, who is beyond outstanding and has really done tremendous work on this bill. I mean it sincerely, and this is only the second bill that has ever come to the Status of Women Committee, so I think it's groundbreaking for all of us to be here and making a difference. And I agree with everything that Leah has talked about, and we did hear about it during testimony. The problem that that we have with the amendment is that when you talk about ensuring that emergency services would be available, we can't direct emergency services as a federal government, and the same with the piece that delves into provincial territorial jurisdiction. So I hope that those watching this meeting, and I know that many are paying really close attention to the intent of what this committee wants, is to make sure that we're keeping women safe. It's only a tool, and I think we've all acknowledged that there are issues in rural and remote and Indigenous communities in terms of access to internet, and the same with access to emergency services. But I don't feel, in fact, I suspect that the justice officials would agree if we were to ask them that this is outside the scope of what we're able to do federally.
On my list, I have Adrian, followed by Dominique, and then I will pass it over to one of the legislators. Do I pass that to you for LEAP? No? You want me to pass that over to the floor. So I'll go Adrian, Dominique, and then we'll ask for judicial support and advice.
I would like to add to what Ms. Damoff just said. Indeed, I think there were witnesses that said that the implementation of this device was something of provincial jurisdiction and of Quebec's jurisdiction. So I'm trying to see how this amendment could be applied. Perhaps the representatives from the DOJ could respond. How would it be feasible? I don't think this would work with the implementation. I think that there are funds currently available. The network is being extended, but funds have been transferred, at least in Quebec, and Quebec is working on the matter of connectivity and internet, so I don't see that this amendment can be implemented. Dominique?
You're on mute, Dominique.
Bonjour Karine, bonjour tout le monde.
Hello, Karine. Hello, everyone. I forgot to turn on my microphone. I don't see things the same way as my colleagues, unless the council says the opposite, but I believe that this amendment is tenable. We're saying that the Attorney General must take all reasonable measures. So I see that in their recommendation. So it's a recommendation to make a request that an electronic monitoring device be worn, and they won't recommend that in a region where it cannot be used. That's how I understood it. We're not asking the Attorney General to or rather, I don't think that was the case. I already raised as well the fact that it seemed that it wasn't only a judge that could request that an electronic device be worn. It had to come from the Attorney General. I would like to have this confirmed. Council is here. They have had a few days to reflect on this, because black on white here it says that the Attorney General must make the request, and I don't see anywhere that the judge must make the decision without having received the request from the Attorney General. Thank you, Madam Chair.
What I'm going to do is ask for some legal advice, and then we'll be coming back to Michelle and then Shelby. Go ahead.
Thank you very much. I'd be happy to speak to that. In relation to, I'll start with the last point first, because that's a question that I've heard come up over the course of some of the testimony that you've heard from witnesses. This question about whether the judge can only impose the condition if the Attorney General requests it. And that's not the case. Even if this bill were not to pass, it's still possible for judges to impose this condition. Under the criminal code and the bail provisions, before a justice releases somebody who's held in custody, there are 3 reasons for detention that they have to consider. They wouldn't release somebody if they had a concern that any of these things would not be protected if they release them. Those 3 factors they have to consider are whether or not the accused person will attend court. They can also detain them for the protection or safety of the public, including victims, and to maintain confidence in the administration of justice. Subsection 515 sub 4 of the criminal code lists the most commonly applied conditions of bail, and 2 particular paragraphs under those lists, and these apply to any case, are paragraph G, where justices can impose any condition that they consider necessary to ensure the safety and security of any victim or witness to the offense, and under paragraph H, they may impose any condition that they consider desirable. So the criminal code does already permit justices to impose electronic monitoring as a condition of release for any offense. And what this bill proposes is that in certain cases, it would mandate that a judge had to consider whether or not they should be imposing a condition of electronic monitoring. So that's the difference that the bill makes. If it were to pass and electronic monitoring is specific. So right now, electronic monitoring itself is not mentioned by name in the bail conditions. It could be imposed if the judge felt that that was appropriate under the considerations that they have to take into account, but it's not explicitly listed. So this bill would explicitly list electronic monitoring as a condition that a judge would have to consider. And in the way that the bill is currently worded, in any time there was an offense before, an alleged offense before the judge, where somebody was alleged to have committed an offense against an intimate partner, then the judge would have to consider imposing this condition.
Okay, thank you. Okay, I'm going to pass it to Michelle, then Shelby.
Thank you, Chair. I think my questions actually might have got answered there, so thank you for that. I guess I was just curious if there's a double benefit to this, and maybe I missed this part as well when we explained how the electronic bracelet works. But I'm just wondering if there could be an extended benefit to this clause in sort of pushing forward more access to internet and services in more rural areas. It could bleed into that. It's just a thought, because I see it as in response to what Dominique had said. I think it's reasonable measures. Like, I think it's the way that it's worded by Ms. Kazan. It says it's within reasonable measures, but I also see a positive coming out of this amendment in that it's saying, hey, we do need access to more internet, if I'm understanding how the electronic bracelet works correctly. And what I'm talking on in particular in my experience here is we as MPs have an emergency fob when we're out, and we can click it wherever we are, and it will employ the police, but it only works if there's cell service. And so I was just my thoughts.
Thanks very much. Passing over to Shelby.
Just for clarification, I think on all of our behalfs, I 100% agree and can voice that none of us have malicious intentions. We're all agreeing that we're here for the right reasons and looking after that of the women and the children. But what we need to recognize is that whenever we're going clause by clause, it's really important that we are reflecting the true testimony that was given. I really think we can't add, we can't take away, we can't amend it to our liking. We have to make sure that it really echoes the voices that were heard in the testimony, because all too often, if committees are adding amendments here and there and changes here and there, we really have to be cautious that it's echoing the voices of what exactly went on during testimony and not just our interpretation of it.
I'm just going to take the chair's prerogative and give it back to Leah, because I think one of the biggest things is we do know that this is probably what we want across the entire country. The problem is it is a cell service. So if anything, there could be a resolution from us that we could take back to the House of Commons saying, hey, get some cell service out there for all of these people that absolutely need it. I don't know if it could be part of the criminal code. That's the only thing. I fully support where this goes. Absolutely.
Yeah, no,
I'm just
no, and
concerned.
I agree. Sorry, Karen. I do recognize that that Leah Kazan, I think her, like, everything is in order, but just moving forward as we progress through the different amendments, as long as we have that in the back of our minds.
Okay, I'm going to go back to Leah, Pam, Adrian.
Thank you, Chair, and just so appreciate this committee. Like, I really do love this committee, but it's so weird. He would think this wasn't politics, but just going back to some of the people, this actually is directly related to the feedback about accessibility. I think, I take Pam's points about the second one. I mean, like, it has to be within the confines of the law. I mean, I appreciate that, with the intent, however, to kind of reflect the deep concerns that were raised by some of the witness testimony. I think in 4.1, and again, I'm not a lawyer, it says all reasonable measures. A device is available that makes the monitoring possible regardless of geographic area in which the accused has been directed to remain. So I think it's all reasonable, knowing that there's issues with cell service. I mean, but to make all reasonable, I think, I could be wrong, but I think that kind of covers that disparity in access.
Pam?
Just on your point, I recall doing this with another bill that we studied. When we studied Bill C-71, actually, public safety, we sent it back with a note for the things that were outside of federal jurisdiction. And I think it would be completely reasonable to send this bill back just with a resolution from the committee that recognizes, because it's not just with electronic monitoring, it's also, we heard testimony about how women are at risk when there's a lack of cell service. So I think sending the bill, it doesn't mean that there's a requirement of the government to act on it, but I think it recognizes the concerns that we all heard, while not trying to get into provincial jurisdiction with the legislation or trying to make requirements, because this is also talking about Attorney General. The rest of the bill is about judges considering e-monitoring. So I think we could come up with something about while outside the scope of the bill, the committee recognizes that a lack of cell service can put women at risk.
We're having a really good discussion, because I'm going back and forth on this one myself, going, do we support it? We do not support it. This is great debate. Adrian, then Shelby.
I would like some clarification from the officials. When we're talking about e-bracelets and conditions, if I understand correctly, this is something that's already being done. And with this bill, that somebody has to wear an electronic monitoring device, that the Attorney General must make a request. I'm not clear how this is already being done. I know here that we want to have better connectivity, but I'm concerned that if it's a condition and there's no connectivity in an area, will it be recommended? And as Pam said as well, in Quebec, we're already working on that e-bracelet device. So I would like some clarification. We've said that the implementation is of provincial jurisdiction, and we're seeing that the implementation is their responsibility. So I would like to understand how this could be implemented, and could you clarify how this is already being done?
Back to the judicial, so I'm going to pass that back to you, Ms. Davis. You're on mute, sorry.
Oops, okay, désolé. Merci pour...
Thank you for your question. As I said, you are correct. It is already possible to impose the use of an electronic monitoring device, the bill would force a judge to impose such a condition in specific cases. Like, for example, if the accused person is accused of committing a crime against their intimate partner.
The previous question, I hadn't specifically spoken to the motion, NDP1, and what the effect of that would be. And it is true that it is not typical that a provincial attorney general would be directed to do something in the criminal code. Looking at it from a legal perspective, it's possible that, as has been raised, that there's not necessarily an enforceability to this. It says that the Attorney General must take all reasonable measures to ensure something after the fact. So that's after the fact that it would be imposed, basically. So as has been described, it's not necessarily criteria that a justice must take into consideration. But already in the way that bail courts operate now, there's a number of provisions that require judges to consider safeties of witnesses. So if a judge is imposing a condition for an electronic bracelet, it would be the normal course that they would look into the availability, the logistics. Is it a jurisdiction where there's a funded program and that province themselves has a program where they make it available? Is it right now in some of the provinces where they don't have programs, an electronic monitoring condition would probably be something that would be proposed by the accused person who has means to pay and doesn't want to be detained. And they would say, look, you don't think I'm a good risk? Tell you what, I'll pay for this. Here are the details. So these are the types of details that judges would be considering. And then, as has been mentioned, some of the other details in paragraph B are things that would fall into provincial jurisdiction in terms of ensuring safety and emergency services. Another matter that the committee might want to consider, Madam Chair, is the way that paragraph B is written. If the accused were to approach any place where any victim, witness, or other person identified in an order made under Section 2 might reasonably be found, emergency services would be available. So some possible concerns that arise sometimes in bail court is, how do you know where that victim might reasonably be found? Right now, the usual course with a condition like an electronic monitoring condition would be to prohibit an accused person from leaving a certain boundary. So they would make sure that there were cell service, or there were sufficient services to cover the boundary that the accused person was supposed to be within. And the bracelet would alert as to whether the accused person either left that boundary, or they could probably program it to indicate if they attended at certain addresses. But one thing they need to consider when they're in a bail court is, do you want to identify the places where a victim might reasonably be found? Because they might want to have places where they go that the accused person is not going to know about. So whether a condition like that would require a victim to share information that might not be better not known to the accused. So they have to think about some of those strategic things when they craft the conditions in a certain circumstance. So those are a couple of considerations for the committee.
Excellent.
With, that portion.
Thank you so much, Shannon. What I'd like to do, I know that Leah I would like to always give Leah the last opportunity to speak, since this is her sponsor amendment. Are there any other questions, or are we all happy? Passing it to Leah for her final words on this.
I actually have a question. So we're talking about policing being provincial jurisdiction, but that's not true actually on reserve, for example, or in certain areas where it's RCMP. Does that fall outside of provincial jurisdiction? Or would that be within provincial jurisdictions? So, for example, if the RCMP are policing on reserve, is that provincial or federal? I'm just wondering.
Pam, I'm going to ask, let's discuss. Pam, you bring a lot to the table. Let's discuss. Where does...
So the justice officials can probably correct me, but they would still any charges related, I'm not a lawyer here, but I'm pretty sure that if they were charges that were laid under the criminal code, it would still be, that would be federal or provincial. Like there aren't separate, other than at Akwesasne, which have their own courts to deal with offenses, and I think those are mostly offenses that are bylaw related, Leah, that even if you're living on reserve, you're still coming under the criminal justice system of the Government of Canada or the province where the reserve is located. Maybe can Justice
So I think,
confirm
yeah,
that?
I was going to say that. So I think what Leah was asking, I really appreciate where you came with, Pam. And Shannon, maybe you can say this. So if we're looking at something that's happening on a reserve where we know it's, the Indigenous, compared to where we have, your OPP, your city police around, who has jurisdiction over that one section? Oh, and no, let's ask Leah. We're going to go to Leah and then to Adrian, and then we're going to come back to you, Shannon.
I particularly related to the policing piece. Like not the courts piece, but the policing piece. Like whose jurisdiction is that?
Okay.
Do you know what I mean? Like if it, okay.
Still enforcing the laws from the criminal code and the bylaws that may have been passed. So if we're talking about family violence and domestic violence, which is we're contemplated in this bill, it would still be, they would be policing under the laws of the Government of Canada. So the police would be responding based on Canada's laws when it relates to domestic violence and family violence.
But they would be provincially regulated, operating.
Well, when it went to, if it went to court, it would be going to a provincial or federal court.
Right. That piece I understand.
Yeah.
It's the policing piece that I don't.
Yeah. So, and it depends on the reserve who's responding. Even if it was the RCMP responding, or if it was like the NAN police service or Akwesasne police service.
So that's tribal police. So like
it is, but they're enforcing Canada's laws, though, Leah, when it comes
Okay.
to violence.
What I would like to do right now is I'm going to take it to Shannon. We're going to come back to Adrian. Shannon, can you give us, especially on this policing thing, I know it's not directly under Justice Canada, but perhaps you can give us a little insight from what you know, and then we'll go to Adrian.
Thank you very much. And my knowledge in this area is not complete. It's a very complex area. So one thing to begin with in terms of when we were talking about the not reserve area and whether RCMP, we know that there are jurisdictions where RCMP is providing policing services in provinces. There are provinces where the RCMP is under a contract with the province to provide services. So those would still be those policing services, although it's quite complex, although the RCMP employees themselves have a federal employer through providing contract policing services in those jurisdictions, they would also be bound by, they would be providing like a provincial service. In terms of reserves, there are different arrangements. It's not the same everywhere. So I think in terms of how we're thinking about this for the purpose of the bill, as has been said, it's a federal law. Everything in the criminal code is a federal law that applies across the country. So where we're talking about the relevancy of provincial jurisdiction here in terms of what the motion is proposing is under the Constitution of Canada, as I'm sure you all know, there's a division of powers for different responsibilities, and the criminal law is a federal responsibility, but the administration of criminal justice is a provincial responsibility. So it's provincial prosecutors and the courts are within the administration of justice for the criminal courts is within provincial jurisdiction. So some of the things, the administration of the devices themselves falls under provincial jurisdiction. So making them available if that's something they choose to do, as well as monitoring their use and enforcement, as is the provision of emergency services. So the things that are being proposed to be written into the bill itself generally fall within provincial responsibility. It's confusing with the criminal code because there is overlap and that's why we call it a shared responsibility. And it's not unusual what the criminal code would direct a police officer to. It would, what's in the criminal code essentially might define police officers' powers in certain instances, but it's not typical that the criminal code would speak to the operational details of how their operation should be run.
Okay. Adrian, you had your hand up, and then Leah, I will always give you the last word before we go to anything. So go ahead, Adrian.
Ok, donc.
So the criminal code, with its implementation, well, could we send back the bill with clearly indicate what is of provincial jurisdiction? And if so, what would that process be? I would like to know what the feasibility is on that specific aspect, because we seem to be in a bit of a gray area on what we can recommend with the criminal code, what a judge can ask for, and then for the implementation. When we're talking about here coverage, we're talking about implementation, the technical implementation of the bracelet, and that's of provincial and Quebec's jurisdiction. So can we mention this in the bill, and if so, what would be the process?
Discussion that there was the option of a resolution that was brought forward that we could talk about. So when we're discussing about that bringing forward, and here are all the other problems that we have not addressed in this bill that we found. So that's another option. Leah, you get the last word.
Well, I'd like to thank everybody for their feedback from the, relating to the proposed amendment, and I'm certainly, not attached to it. But I think going back to what Pam recommended at the beginning, in terms of not necessarily excluding it as an opportunity to discuss some of the gaps, particularly around cell service and accessibility, to ensure that testimony that was provided is very well reflected in the bill, or even if it doesn't make it into the bill, the discussions around the bill.
So as the committee chair, I will ask the clerk in my notes to ensure that we do have these outside of recommendations. So you and I can discuss, and we can discuss that when I report this back, that there is something that we did recognize, that there are many outstanding factors that we need to bring forward, and then we can even put forward a clear resolution from our committee in time, for sure. So what I would like to know is if this clause shall carry, this will be a vote, a recorded vote, correct? Oh, yes, this is where you call me. Yes, sir. Philippe? I'm going to start the question on the amendment from Leah Gazan. So the question is on the amendment. Can I see those in favor? Or it's a recorded vote, so I'm going to pass it to the clerk.
Ms. Lambropoulos?
Nay.
Ms. Dalmoff? No. Ms. Sidhu?
No.
Ms. Suds?
No.
Ms. Vandenbeld?
No.
Ms. Ferrari?
No.
Ms. Cramp-Newman?
Nay.
Madame Bien?
No.
Madame Larouche?
No.
And Ms. Gazan?
Am I going to make it? Just kidding. Or is there hope here? No. I'll support the recommendation of the committee.
At least we can laugh when we were doing such a serious bill. We can at least still find hope. Okay, I'm going to now pass it on to Liberal Amendment 1. To that, Ms. Sadhu, I'm going to pass, Ms. Sadhu, I'm passing you the floor for Amendment 1.
Thank you, Madam Chair. So I won't read my amendment because I think everyone has it in front of them. But the rationale behind that, Madam Chair, is that I know that we will all agree that bill's changes to the bail practices are an important objective. At the same time, we need to ensure that the measures do not result in intended negative consequences. Based on some of the testimony we heard, I'm concerned that further than the necessary and result in the routine imposition of electronic monitoring as a condition of bail.
Okay. Discussion from this amendment. Anyone on discussion on this so far? Adrian? No, you kind of.
Juste nommer que c'est tellement logique.
I just want to say that it's very logical and it represents what our witnesses said.
Pam, she had said that it's very logical, and this is repeating what the witnesses have said.
Merci.
Any further discussion? Oh, good. Dominique, I have you. Dominique?
Merci.
Thank you, Karen. I understand the amendment. I just have a question between the text that I have and the amendment. The fact that we're qualifying this amendment with attempted violence, and are we perhaps limiting ourselves because there could be other situations, but I don't know if we're limiting ourselves by writing these specific cases. I get the impression that the fact that the way that the bill is currently written, there are no restrictions. I'm not saying that there will be any by adding these words with violence, but we're adding conditions, and perhaps I'm wrong.
Okay, what I'd like to do, I see Sonia's up, but I would like to pass this over to Shannon. Shannon, can you give us a little, what would the impact of this be to this bill and the criminal code?
Thank you very much for the question. As I had mentioned, the focus on these amendments in relation to the bail provisions are to define the situations in which the judge is obligated to consider imposing this question. So the effect of making this amendment would actually be, so there's a list of offenses in paragraph 4.3 of section 515 of the criminal code, and it lists certain offenses or offense groups for which the judge has to consider imposing the conditions that are listed in section 4.2. So those are offenses like a terrorism offense, criminal harassment, intimidation. It does currently list an offense in the commission of which violence against a person was used, threatened, or attempted. And there's also offenses in relation to the Security of Information Act. So by making this amendment and slightly narrowing the situations in which a judge would have to consider imposing this condition, it kind of brings it more in alignment with the other types of offenses that are currently listed in the code that trigger the imposition of these specific conditions. And it also lines it up with the considerations that a justice have to take into consideration that I had mentioned before. There were 3 of them. One of them was related to safety. So it links it to that safety aspect. It's true that there are other situations where there might have been an offense against an intimate partner that could indicate that there was a violence concern, and that there, but as I had mentioned before, the judge could still impose it in those situations. So it doesn't take away the ability to impose it in those situations. It just helps narrow the focus for the way this section of the criminal code tends to be used.
So what you're saying, I really do appreciate this feedback. So really it's describing this is what you're going to see in here. So it's just giving, like you said, it's narrowing, but it's also getting it very focused on what we need to do, which is talking about the violence against the sexual and physical and the abuse that we're seeing, the intimate partner violence. Okay. So it's just narrowing down on IPV.
And just to note that the wording that's proposed in the motion is violence that's used, threatened, or attempted. So it does include, in the criminal code, that would include other things like uttering threats, criminal harassment, those other types of things. Violence isn't just physical violence.
Absolutely. Okay. Okay. Adrian, you're right. You had your hand up. Oh, no. Okay. I just saw you moving. Okay. So what I'd like to do is I want to go back to Sonia as the person who brought it forward. Any last comments?
Yes, absolutely. Madam Chair, as we heard, this change continues to advance the objective of the bill, and judges will still be able to impose electronic monitoring for any offense where it is more appropriate, as the bill seeks to do under existing powers. So as with all aspects of criminal law, we need to ensure that measures do not have any negative consequences. With that, Madam Chair, I would be happy to go to a vote if there's no more discussion.
Yep, not a problem. Okay, so I'm going to ask for a recorded vote on Lib Amendment 1. Okay, passing it to you, Clerk.
Ms. Lambropoulos,
In favor.
Ms. Damoff,
In favor.
Ms. Sidhu,
Yes.
Ms. Suds,
In favor.
Ms. Vandendal,
In favor.
Ms. Ferrari,
Yes.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 years.
11 yeas. Way to go. Wow, we're a unanimous kind of committee today. Way to go, everybody. Will new clause, okay, shall clause 1 carry as amended? Did you see that I got that, sir? Thank you, Philippe. Did we do a recorded vote on this one? I think we're going to just put everything in. We're just going to get it. Philippe is telling me what to do, and he really knows, so I'm just going to keep to the clock. Shall clause 1 carry? And we got a recorded vote, please. As amended. Go for it.
Ms. Lambropoulos,
Yes.
Ms. Damoff, Ms. Sidhu,
And do we vote on
Yes.
clause 1?
Ms. Suds,
Yes.
Ms. Vandendal,
Yes.
Ms. Ferrari,
Sorry. Yes.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
so 11 yeas, 0 nays.
Wonderful. Thank you so much. We're now going to move on new clause 1.1, Liberal 2 amendment. If I could have Ms. Ledoux, if you could share it with us, please.
Madam Chair, we are proposing a new class. Pam will speak on this. Over to Pam.
Is that okay, Chair? Okay. So I know that Jennifer Kagan is watching right now, and this was the amendment that Jennifer and Philip felt very strongly that be brought forward on the bill. So this will include the requirement that a new judge undertakes to take training on domestic intimate partner violence and coercive control. The other thing that this bill or this amendment does is you'll notice that the wording is different than what is already in the bill in another clause, and I'd like to just explain that to colleagues because it originally was just intimate partner violence and coercive control. We're proposing that coercive control be more because it doesn't exist in the criminal code, that it be defined to include an intimate partner and family relationships, and also ensuring that the words appear prior to the word social context. So it is ensuring that social context not only is taken into account under sexual assault law, but also intimate partner violence and coercive control. So this is adding a new clause to the bill that's not there now, but it does bring it in line with what the original Judges Act contemplated, that both new judges would undertake to take training as well as seminars be provided for current judges. So I think it follows the intent of the original Judges Act, which we passed unanimously. So I'd like to ask colleagues to support including this clause and recognizing why the additional wording around coercive control is there, as well as moving it in front of social contact to reflect testimony that we heard.
Thanks very much, Pam. I'm going to pass it over to you, Shannon. If you could give us some of the look on how this would apply to the criminal code, if it's admissible, if everything's good, everything's in line, please let me know.
Thank you very much. I'm sorry, I just, as I was going through the motions, I think I was looking at the wrong one. I'm looking at the package as it's put together, and we're looking at Lib 3 right now.
Looking at, we're looking at Lib 2 on this one.
Oh, okay, thank you very much. So, yeah, this one would be an amendment to the Judges Act. I'm going to ask my colleague from Judicial Affairs, Melissa Moore, if she could answer this question, please.
Certainly. Thank you, Shannon, and thank you for the question. As the member speaking to this motion noted, this motion would expand the undertaking that's currently found in Section 3 of the Judges Act through this new clause that's being proposed to the bill. So at the moment, the undertaking in the Judges Act relates to seminars on sexual assault law and social context. It means that in order to be eligible for appointment to a provincial superior court as a judge, a candidate must undertake to participate in continuing education on sexual assault law and social context. From my understanding of this proposed amendment, so adding the new clause to the bill, this proposed amendment would expand that undertaking so that candidates seeking judicial appointment to a provincial superior court would also be required to undertake to participate in continuing education on intimate partner violence and coercive control.
Thank you very much. As the House of Commons Procedure and Practice, third edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of this bill. Unfortunately, I believe that this is outside the scope of the bill. I'll just from the support that I've had from the clerks and people working on this. In the opinion of the chair, the amendment goes beyond the scope of the bill since the conditions of the appointment of the judges is not envisioned in the bill. Therefore, I rule the amendment inadmissible. We're now going, shall Lib 2, only if the question is decision, never mind. Yes, go ahead, Adrian.
Just to clarify, there was a moment where interpretation wasn't working, or I wasn't able to receive interpretation because the interpreter said he did not have the text that you read.
Of Commons Procedure and Practice, third edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, the amendment goes beyond the scope of the bill since the conditions of appointment of judges is not envisioned in the bill. Therefore, I rule the amendment inadmissible. I think we also have to recognize there will be many opportunities. I think this bill creates an excellent foundation in addition to what we have seen from the previous bills that when we talk about judicial or the Judges Act, I think we need to continue to work on this, but unfortunately we won't be able to speak on this today. I would like now to go to Clause 2. Everybody, Clause 2, Liberal 3. If the sponsor of Liberal 3, let's just see who that may be. I'm going to pass it on to Ms. Sadu. Ms. Sadu, if you could introduce, please.
Madam Chair, Pam is speaking on that as well.
Thank you. Thank you, Chair. I just have to look to see what this one is. It's moving the wording, as I spoke to previously, of intimate partner violence and coercive control so that it precedes the word social context, as well as adding in coercive control in intimate partner and family relationships and social context. The other thing, so my apologies, sorry I forgot, the French wording needs to be corrected because the term intimate partner violence is currently used throughout the bill, and use of the term family violence in the French text of the bill would create inconsistencies within the bill and corresponding legislation. So I'm just seeing if I have the French words that should be here. We should modify the French version of the bill to mirror the English, as that would be consistent with the other provisions of the bill.
Okay, so let's deal with let's deal with the English and French issues first. Let's deal with that, and then we'll get over to the equality and everything to do with that. To the legislative clerk, can we just, I don't know if you're the one answering on this, but when it comes to a change in the wording, what should we do, sir?
Thank you, Madam Chair. Do you have the wording already, by chance?
do I have the wording? I'm looking at the French version, but I don't read French well enough. I'm wondering if the officials can provide us with the wording that should reflect the English in the bill.
Actually, I'm also going to look at my Virginie. Virginie, can you? She is excellent on French and English. If there's something you would suggest too, we're going to go to the officials, but if there's something on within our group that we can think of, if there's words or something like that as well. Okay, so I'm going to pass it over.
Thank you, Madam Chair. I'm just taking a look, since I'm thinking on my feet on this one, just taking a look to see if I had any suggestions for how exactly that would be worded.
Shannon, if I could jump in, I think it was violence entre partenaires intimes.
Yeah, I'm just getting, that's how it, thanks Claire, and that's how it's used in the other parts of the bill already, so this would make it consistent with the terminology in the bill.
Okay, so Pam, did you want to provide it to, what's the best? Do you want to just read it into the record, or what would you like to do? What's the best thing to do?
Well, the wording should be violence entre partenaires intimes. Intime?
Is that the only difference there? And that's, according to Philippe, that is what's there from the original?
I'm not sure if we're looking at the same thing.
Okay.
No, right now it says, where we say intimate partner violence, here it says à la violence familiale.
So you would need to replace à la violence familiale in the French with violence entre partenaires intimes.
Just give me a second. I do have something here. We are working with this because it is the difference between la violence familiale and intimate partner. So we are just going to work on that. To everybody, just one moment.
In the clause itself, it's written violence entre partenaires intimes. It's just in the recommended change that it's written differently. So perhaps use the wording that's already in the clause itself and replace the amendment with the correct wording.
I know Philippe is just working on it right now, so we will come back with a suggestion. But thank you very much, Emmanuel. That's what we have seen as well. So thank you.
So thank you, Madam Chair. In the English version, the first line reads AL, assault law, comma, intimate partner violence, and that's what the problem lies. In French, we have sexuel, virgule, à la violence familiale, alors que ça devrait être à la violence entre partenaires.
Where it should be intimate partner violence. So you'd have to change violence familiale with violence entre partenaires intimes.
So I see that that's a pretty clear suggestion. I know Emanuela has brought it up. It's just ensuring that family violence is not used in French on that part of the clause. We want to make sure it's intimate partner violence. So the change would be à la violence entre let me put on these glasses, partenaire intime. So that would be what we're looking at. So what we need to do is, I think the discussion is pretty simple on this one, because I do believe we would all be in agreement, and we just would need to accept the sub-amendment to ensure the French version is in line with the English version. Correct? Oui?
Thank you, Madam Chair. I don't think there is the need of sub-amendments. It's Ms. Dartmouth moved it at the same time, so it's included in the original version.
So there's no reason to have a vote on this. We're good to go on that amendment when it comes to the French language.
Yeah.
Excellent, excellent. Okay, so any discussion? Okay, Leah. So what I'm doing is the writing list. If anyone has questions, comments, anything like that, Leah, it's over to you.
Yes, thank you, Chair. So I do support the amendment, and I'd like to, in light of that, withdraw my amendment for the next one, because it's reflected in the motion. So I'd like to withdraw my motion.
So NDP 2 is being requested to be withdrawn. I don't see that being a problem unless everybody's saying, no, we're dying for this one. Fantastic. Okay, so additional conversation on Liberal motion. Any additional questions, comments on this? Go ahead, Adrienne.
Encore une fois, je pense.
I think that's what we heard, and it reflects the testimonies that we heard at our committee. So for all those reasons, I think that we should move forward with this.
Absolutely. So I think this is just a simple one there. Absolutely. Any other further discussion on this? Pam, give you the last words.
Thanks, everybody, for your support on this.
Fantastic. Okay, so we're going to see. Let me get my rules of what I need to do next. Philippe, I'm on this. So we're going to be looking at Liberal 3. Shall Liberal 3 amendment carry? We're going to start off recorded vote, please.
Emanuela, Ms. Lambropoulos, sorry.
Vote in favor.
Ms. Damoff?
In favor.
Ms. Sidhu?
Yes.
Ms. Suds?
In favor?
Ms. Vandenveld?
In favor.
Ms. Ferrari?
Sorry, yes.
Ms. Cramp-Newman?
Yes.
Did we hear her?
I heard her, but that's. Okay. Go ahead, Shall be a little louder.
Yes.
Okay. Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Oui.
11 yeas, 0 nays.
Fantastic. Okay, guys, let's keep on winning. We're winning here. Fantastic. So, shall Clause 2 carry as amended? Recorded vote, please.
Ms. Lambropoulos?
Yes.
Ms. Damoff? Yes, sorry. Ms. Sidhu?
Yes.
Ms. Suds?
Yes.
Ms. Vandenveld?
Yes.
Ms. Ferrari?
Yes.
Ms. Cramp-Newman?
Yes.
Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Yes.
11 yeas, 0 nays.
Fantastic. We're now moving on to Clause 3, and I'm going to pass it off to Ms. I think this is Ms. Sidhu again. Ms. Sidhu, I'm going to pass this over to you for Liberal 4, and if we're passing the floor to Pam, are you going to?
Madam Chair, Emanuela will be speaking on the next two.
Okay, Emanuela, passing it to you.
Just to throw you off a little, Madam Chair. So in this one, we're actually going to be changing it so that after in Clause 3, lines 4 to 7 on page 2 are replaced with the following: matters related to sexual assault law, intimate partner violence, coercive control in intimate partner and family relationships, and social context, which includes systemic racism and systemic discrimination that were offered in the proceeding.
Excellent. Thank you so much. Any comment from that, Emanuela, or just?
It's just a change of the way that it's written, but pretty much all of the same things have been captured, and it's a better reading of the way that it's I guess better placed like this. It sounds better.
So is this your English teacher coming out of you right now? Is this what's happening? The teacher's coming out. I'm going to pass it over to Shannon for if you could discuss the impacts of this change.
Thank you very much, and I'll ask my colleague Melissa Moore to speak to this one as well, please.
Certainly, thank you. So this motion is in relation to Section 62.1 sub 1 of the Judges Act, which encourages the CJC to report on certain seminars. So currently, the bill would expand that report to include seminars on interpersonal or intimate partner violence and coercive control. My understanding of this motion is that it would mirror the changes made to another section of the Judges Act in Lib 3. So it would change the order in which the topics are referred to. So it would read sexual assault law, and then it would say intimate partner violence and coercive control, rather than adding those two at the end of the clause. And it would also specify, as in Lib 2, that coercive control is coercive control in intimate partner and family relationships.
Okay. Any comments or questions on this? Any discussion on this? Go ahead.
C'est d'être conséquent avec.
So we need to just be coherent with what we voted earlier as an amendment.
Absolutely. It's just really staying in line. We're just keep tightening up the language. Okay, so we're going to move on this. Shall Liberal 4 carry? If we could get a recorded vote, please.
Ms. Lambropoulos?
In favor?
Ms. Damer?
Yes.
Ms. Sidhu?
Yes.
Ms. Suds?
In favor?
Ms. Vandenberg?
In favor?
Ms. Ferrari?
Yes.
Ms. Cramp-Newman?
Yes.
Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Yes.
11 yeas, 0 nays.
Fantastic. Wonderful. And shall Clause 3 carry as amended? Recorded vote, please.
Ms. Lambropoulos?
Yes.
Ms. Damer?
Yes.
Ms. Sidhu?
Yes.
Ms. Suds?
Yes.
Ms. Vandenberg?
Yes.
Ms. Ferrari?
Yes.
Ms. Cramp-Newman?
Yes.
Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Yes.
11 yeas, 0 nays.
Yay, way to go. Okay, so now we're moving on to Liberal 5, which is in Clause 4. We have Emanuela, if I'll turn the floor to you.
Yep. So that Bill C233 be amended by adding after line 9 on page 2 the following new clause. Title coming into force. 4. This act comes into force on the 30th day after the day on which it receives royal assent.
So my only comment is this so that we can get it as soon as possible so that we can make sure everybody's safe. Is that the plan here, Emanuela?
Of course, that is the plan.
Fantastic. So, and can I pass it over to Shannon for some insight?
Thank you very much for that question, Madam Chair. So if this motion was not passed, then the bill would come into force, I believe, upon royal assent. So by delaying the coming into force of the bill for 30 days, that gives the provinces and territories some time to familiarize themselves with the law, to put anything in place that they need to facilitate its operations, and it's something that they very much appreciate. Otherwise, the law changes overnight and the people in the justice system are not necessarily aware. So it just gives everybody time to inform themselves of their obligations and how best to implement the new laws.
Excellent, fantastic. Any questions or comments? Go ahead, Adrienne.
Oui, on rappelle.
It's to also give Quebec and the provinces to implement it. I think it's more reasonable than 30 days.
Okay. Okay, any questions or comments on that? Emanuela, for a follow-up? Any thoughts? So I'm sorry, I just want to check on this, Adrienne, because maybe I wasn't listening for a second here. But on that 30-day, are you saying that's good? You're good with the 30 days, or you're all positive? You're in support of that?
Oui, je disais que ça laissait le temps au Québec.
Yes, I was saying it gives Quebec and the other provinces enough time for implementation.
Fantastic. Okay, I just want to make sure we're on the same page. And Manuela has no other comments. Shall Liberal 5 carry? Can we have a recorded vote, please?
Ms. Lambropoulos?
In favor.
Ms. Damer?
In favor.
Ms. Sidhu?
Yes.
Ms. Suds?
In favor?
Ms. Vandenberg?
In favor.
Ms. Ferrari,
Yes.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 yeas, 0 nays.
Excellent. Thank you so much. Okay, so we're on to that. We're- The new clause is there. I just want to make sure we have everything going here. Everything looks like it's fine. So now let's get on to this title of this. It is an act to amend the criminal code and the Judges Act, violence against an intimate partner. Shall the title carry? A recorded vote, please.
Ms. Lambropoulos,
Yes.
Adopté.
Yes.
Ms. Dameff, yes. Ms. Sidhu,
Yes.
Ms. Suds,
Yes.
Ms. Vandenveld,
Yes.
Ms. Ferrari,
Yes.
Ms. Crank-Newman,
Yes.
Madame Bien,
Excusez-moi, je me croyais dans un autre parlement tantôt. Oui, oui, bien sûr, adopté.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 yeas, 0 nays.
You guys are just being too easy on the chair today. Shall the bill as amended be carried? Recorded vote, please.
Ms. Lambropoulos,
Yes.
Ms. Dameff,
Yes.
Ms. Sidhu,
Yes.
Ms. Suds,
Yes.
Ms. Vandenveld,
Yes.
Ms. Ferrari,
Sorry about that. Yes.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 yeas, 0 nays.
Excellent. Shall the chair report the bill as amended to the House? Is this a question or is this a?
Yeah, it is a question, because I was going to give, actually two now, recommendations to go back with the bill. So do I need to do that now or after we pass the bill? I just want to make sure that when it's reported back, that it goes with it.
Just one second. As I'm being told, when I cannot provide recommendations, though I do know that we need to talk about some other things called resolutions that we want to make sure we see in there.
So on Bill C-71, we did include recommendations when we reported the bill back. So it must be possible to do.
Please, Philippe.
Thank you. Thank you, Madam Chair. When a committee studies a bill, the only thing that appears in the bill, in the report on the bill, are amendments that were adopted by the committees or clauses that was removed from the bill by the committees. Those are the only thing that can appear in the report on the bill. Now, what you could have is a second separate report that's based on the study on the subject matter of the bill, and that's where you could do it, but it would be separately from the report of the bill.
Okay. Sounds good.
Fantastic. And I know we have lots to talk about on that, Pam, because I think you and I are probably already in that next lane thinking, where do we go next? So I fully understand where you want to go with that. So shall the chair report the bill as amended to the House? Recorded vote, please.
Ms. Lambropoulos,
Yes.
Ms. Dameff,
Yes.
Ms. Sidhu,
Yes.
Okay.
Ms. Suds,
Yes.
Ms. Vandenveld,
Yes.
Ms. Ferrari,
Yes.
Doing okay.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 yeas, 0 nays.
And shall the committee order a reprint of the bill as amended for the use of the House at the report stage? All those in favor? Recorded vote, please.
Ms. Ms. Lambropoulos,
Yes.
Ms. Dameff,
Yes.
Ms. Sidhu,
Yes.
Ms. Suds,
Yes.
Ms. Vandenveld,
Yes.
Ms. Ferrari,
I just need to leave it off on mute. Yes.
Ms. Cramp-Newman,
Yes.
Madame Bien,
Oui.
Madame Larouche,
Oui.
Ms. Gazan,
Yes.
11 yeas, 0 nays.
Fantastic. Well, congratulations. I know that this may not be exactly what people want to see, but we've got this bill as a great foundation and being reported back to the House next week. So congratulations, guys. We got this all done. I do want to move forward, though, on the discussion that we did have where we were talking about that resolution. We do know that there are some things that we want to see and discuss. Perhaps Philippe can tell me, I can report the bill back, which I can do, but can then I continue and say, but we have a heck of a lot more ideas that we have where we discuss the things that Leah had brought up, discuss the one that we, of course, we saw a motion that was out of order or an amendment that was out of order. Is there a way that our committee can report back to the House and talk about some of these issues that we did not address? Is that something that, I know it's different, but we're status of women, we're always different. So what do you say, Philippe?
No.
Oh!
But no, not really. But what you could do is address the situation that you have not covered here today or during your studies at third reading.
Okay, no, I'm going to disagree with you here.
Okay, Pam's going to disagree. I'm going to pass the floor
Because
over to...
I very specifically remember sitting at Public Safety Committee having concerns around a number of issues, including red flag, that we were unable to address in the bill. And when the chair reported the bill back, we included those concerns in some way. So it happened at committee. I know I drafted it, and I know that it was done. So I know you're an amazing legislative clerk, and you were probably the person that was sitting in the chair. I don't know how we do it. Can we pass a resolution here today that the chair can report other resolutions back to the House? So could we pass a motion today that the chair report to the House on 2 issues, that she would table the bill, and then we could pass a motion that the status of women calls on the Government of Canada to blah, 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 blah. Could we do that?
That's more of a question for my colleague.
Okay.
Just point of order, Madam Chair.
Sonia, is it on this that we're discussing right now? What is? How can I help you? Sonia?
Just Madam Chair, can we let just official go? Then we can discuss.
Oh, yes. You know something? That's a great idea, Sonia. So I would really like to thank the officials that are here with us today. Thank you so much to Shannon, Claire, and Melissa for being here to provide your insight on this bill. Philippe, I'm not sure if we're going to get rid of you or not. You might be stuck with us. Are you? So I would like to thank you for being witnesses and relieve you from your role here today. So thank you so much.
Thank you very much.
Thanks, Sonia, for bringing that forward. I do appreciate that. But from this discussion that we're having, this may be an opportunity for us to put forward this resolution. This is something that we've all discussed. I know it's important to everybody. So perhaps we can work on a resolution that over and above. So here's your report. I'm reporting it back. But then our committee has also adopted this resolution on this. Perhaps we can get starting on a resolution, because I think from Bill C-233, this has opened up a can of worms that we know that there's more to be done. So perhaps... Is that okay? Am I working it okay, or am I just making up my own rules?
Yeah, I can provide something for you.
You go for it.
So page 776 of Procedure and Practice of the House. On the report to the House, the committee is bound by its order of reference, the bill, and may report the bill only with or without amendments to the House. Consequently, the committee may not include substantive recommendation in its report. And further down the paragraph, however, there is nothing to prevent a standing committee under its permanent mandate from presenting a separate report in which it sets out substantive recommendation with respect to the subject matter of the bill. So the chair would report the bill to the House as adopted today with the amendments. So basically the report would contain all the amendments that were adopted today. And when you table the report, you can also say that there's other recommendation that may come down later on, and that would be in a separate report from the committee.
Okay. That accomplishes what I wanted.
I think that's really important that we're doing that, and I think that is, we can come up with a resolution. So if you can get Connor on this, Pam, I know we work a lot with Connor. I'm looking at Scott, who's over here, sorry, just to everybody. Sarah now. I'm just looking around saying, I like when it's Old Staff Day. But is there a way, Adrian, we're just still on this discussion here, but I would really like our committee to perhaps do that. Pam, I'm going to go to Adrian because is it on the same subject or different?
En fait, j'ai une préoccupation.
I have a concern. I understand that we could do a second report with what wasn't included in the bill, but could represent some of the things that we heard from witnesses. Is that correct? A second report? But we would have to have the time to examine the recommendations and to examine the information. Would we be able to do that between 3 o'clock today? Do we have a meeting to talk about the report that would accompany the bill? What would be the next steps?
I do really appreciate that. I'm going to pass this over to the clerk for a second, and then I'll give you kind of where we're at right now, because you're absolutely right. Every minute in this committee really counts right now. So let me pass it to the clerk.
So the committee could adopt a motion or resolution. Well, it would be a motion pursuant to 108.2, which would make recommendations and have the committee report back to the House. It would be just any other motion, so it would need to be put on notice 48 hours in advance, unless there is a committee business meeting where motions don't need to be put on notice if it's related to matters that are being discussed, so a committee business portion of the next meeting. So it could be something that could be presented and moved at the next committee business meeting, and then the committee could debate it and vote on it.
Another question for you is, when we're reporting back to the House, I do not believe there's any dissenting report. There's nothing, correct, sir? Philippe, there's not. When I'm reporting back to the House, I wouldn't have a member from any other party, just myself as the chair, correct? Fantastic, because I was just going to say if there's a way that we could work that around. Go ahead, Pam.
Just a question, Chair. I think that the two issues that the committee would be concerned with are the cell service, which was Leah's amendment, which we didn't include, and also I think there's going to be, I know there's a tremendous disappointment that the amendment about the undertaking for judges wasn't included, and so I think those are the two issues, and I think maybe the clerk could clarify, but if the motion has to do with what we're discussing today, I don't think we need 48 hours notice if we wanted to do it today. I have some draft wording. If that way, Karen could present it at the same time as the bill, rather than waiting. But if members would prefer to wait, that's fine. I just think I know there's a lot of disappointment around the one amendment being ruled out of order, which I know the chair had no choice to do, but also grave concerns we have about cell service and the e-monitoring. So is that possible, and would members want to entertain that?
I'm going to pass it over to the clerk, please.
Yeah, absolutely. If the motion is moved today and debated and adopted today, there's nothing stopping the chair to report back to the House. She could table two reports, so one report after the other. Yeah.
Okay, I saw Adrian and Leah. Leah, I'll go to Adrian, then over to Leah.
Non, pour le moment, j'avais.
No, I didn't have a hand raised for now, but as Pam said, and there's a thing that I would like to say. I have a concern. If we are able to add recommendations, we need to have the time to do so.
So there is no recommendations that would be added to this bill that we're discussing. It would just be comments or resolutions that and working off some of those things. So I absolutely understand where you're coming from. I think we do have to have a broader discussion on this. It's just not something we can do in 5 minutes, but I do understand. Leah, I'm going to pass it to you.
Thank you, Chair. I do think, I do support moving a motion today. A couple of reasons. One, out of respect for Jennifer Keegan, who put forward an amendment that fell outside. I think, we owe that to the sacrifice that her and her family made. I think that's critical. The other thing is, I'm saying this because I want it on record, a lot of these programs that come about, including e-bracelets, don't impact a population that's been identified with the highest rates of violence, which include Indigenous women and girls, many who will not benefit from this program. And I think, just to be on record saying that. So I think, having that in a motion, making sure that motion gets out today, I think is really critical and in honor of the crisis of murdered and missing Indigenous women and girls as well. Thank you.
I'm going to take the opportunity to take the time as well. What I would like to do is suggest to the committee that we take about a 7-minute break, suspend for about 7 minutes. That would give time for Pam to work with us to get things written. Give time for me to go down the hall. If we could suspend 7 minutes, we'll come back in 7. to your seats. Let's see who can get back the fastest on this. Fantastic. Although we have not received, oh, and Shelby, thank you very much for waving at me. I don't know if everybody else is still online. We have Dominique, are they still there? Oh, fantastic. Okay, so Adrian has received a translation that's, it's tight, but it's not from the Interpretation Center. So I'm going to ask for Pam to read it into the record so that the translation can also be heard in the interpretation for Adrian, and then we'll allow it to go to debate. The most important thing right now, and I see it from all of these committee members, this is something that we all want, so let's get this stuff going. So when Pam is ready, I will pass it over to the floor, and we will have this read into the record.
Sorry, Madam Chair, there is a part to put at the beginning that is exactly the same as what we used previously, so I don't have that written down. It's just pursuant to Standing Order 1082, the committee has considered Bill C-233, an act to amend the Criminal Code and the Judges Act, violence against an intimate partner, and wishes to make the following recommendations to the government. And then the recommendations would be that the committee considered issues and consequences around the availability of self-service in the use of e-monitoring and recommend the Government of Canada move as soon as possible to ensure access to self-service is available across Canada, and that the committee feels strongly and recommends that when developing training for new judges, that issues of intimate partner violence, coercive control in intimate partner and family relationships, and social context be included.
Okay. Any discussion from that resolution? Taking chair's prerogative. Thank you, Pam. I think these are extraordinary and very, very important to this. Thank you for working with Leah to ensure that this discussion is brought on into discussion as well, because although we know there's some provincial jurisdiction, we do know that the federal government needs to work on that. Any further discussion from this? Can we take a vote? And Madam Chair, we're going to ask for a recorded vote since we've done that all day. Okay? How about we just do a recorded vote just to make sure everything's in line? Go ahead.
Ms. Lambropoulos?
I support.
Ms. Dameff?
Yes.
Ms. Sidhu?
In favor?
Ms. Suds?
In favor?
Ms. Vandenbeld?
In favor?
Ms. Ferrari?
Yes.
Ms. Cramp-Newman?
Yes.
Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Yes.
11 yeas, 0 nays.
You put that 12 because I want to vote on this one too. I know. And, Mike, I'm sorry. So I am proud to be able to report this back with the bill. In that report, I am proud to be able to do this. Seeing no other business on the schedule today, I would like to adjourn this meeting. Adjournment? Seeing no problem. Emanuela, you have your hand?
My hand was up, sorry.
Oh, sorry, I wasn't paying. I was just happy about getting this through because it's so important. Yeah, go ahead, Emanuela.
Yep, so thank you. I'd like to move my motion that I brought at the last meeting, and so I'd like to read it once again and officially move it. So that the Standing Committee on the Status of Women report to the House that A, access and availability to reproductive health services no matter where one lives in Canada, including safe and legal abortion, is a charter right and is ensured under the Canada Health Act, and B, the decision to have an abortion made by women, transgender, and non-binary individuals for any reason is their freedom of choice and theirs alone.
Okay, fantastic. Any discussion from this? Shelby, you have your hand up. You'll have to come off mute. Yeah.
There we go. I just think we've come so far and we're making so much progress with current studies. So I would move to adjourn debate on this particular motion with conditions. I'm suggesting that we could discuss the motion once C-233 is completely done, reported back to the House, and all good. The intimate
Let me act as chair,
study
please.
has been completed, and all witnesses on the resource development and violence against women and girls study has been heard.
Okay. So I hear a lot of chatter on this, and I'm going to take the chair's prerogative once again. We can choose to actually discuss this, or we can choose to lose this as a political football that I have seen like for the last few months. So after we just had, I'm going to actually put my foot down on this one right now because I'll be honest, a little upset. We have just come through an extraordinary, I see your hand. We have just come through an extraordinary study of Bill C-233, where we've proven that we can work together very, very well. I'm going to let you guys know, this is not going to be coming up in the next 3 years. You guys are you're in a minority government with the support of the NDP. I fully respect that. I know people want to respond. But I'm just hoping that this committee can continue to do the excellent work that they want to do. And instead of bringing the politics, that we actually worry about women in this committee. I understand that. I really get annoyed when I think that people think that they're more right on this one. And so I'm going to discuss this. We can carry this out. We have a decision as the Status of Women Committee, whether we want to join in the politics that is being brought of divisiveness, or whether we want to actually do what's right for women. We know what the vote's going to end up like this today. And we know, and perhaps I can ask this committee, is if we can just go. I know how the resolution is going to be. I know what I'll be taking to the committee, and I know the votes are actually fine. But what happens when we take it to the House? Are we going to waste 3 and 4 hours of concurrence? Yep. So perhaps is there a way of putting this through that we're not going to wait, we'll have the vote today, I report it back to the House, and there's no concurrence motion so that we don't waste 4 hours of debate in the House of Commons. And waste is not a time. But if you can tell me that abortions are going to end tomorrow in this country, if you can tell me that in the next 3 years abortions are going to end in this country, I would take this as not a political football. I would take this as the urgency for all Canadians. We need to make sure that there's different things. And Anita, I see you getting angry. It's great that you've come here. No, I am the chair and it's my time. It's my time at this moment.
Actually, point of order though, Chair.
Go ahead.
There was a dilatory motion put forward to adjourn debate, and there's no debate on a motion to adjourn debate, so we should probably move to that.
Okay, not a problem.
Let's just adjourn.
Yeah, go ahead. Yeah, that's what I thought. Because there's conditions, and this is where I was thinking, is a dilatory motion with conditions, which is debatable motion, just to let you know, but we can't have 2 debatable motions at the same time. The debatable motion is now on the adjournment with amendments, or with conditions. Because we've gone from something that currently is debatable, has an end. She's asked for a dilatory motion with conditions, but the conditions were also put in there where the conditions then now become what we're also debating if we adjourn with these conditions. The conditions are that Bill C-233 needs to be reported and the intimate partner violence needs to be addressed and tabled. So that's what's really important. Do we want to make sure that we're putting in the time for the intimate partner violence and make sure that those studies get done? Or do we want to continue to debate this? So the debate is on whether we adjourn with conditions. Go ahead.
I did not hear the conditions.
Go ahead, Shelby, if you could put forward the conditions.
Thank you, Chair. I'm suggesting that we discuss this motion once C-233 is reported back to the House, the intimate partner violence study has been completed, and all witnesses on the resource development and violence against women and girls study has been heard. Thank you.
The conditions are that we finish all the witness testimony for the Indigenous and natural resources. That's all scheduled for the next, we should be done there shortly. We will also be finishing Bill C-233, which we'll be tabling on Tuesday. And we'll also be starting the draft on Tuesday of the intimate partner violence. With that, we also have the estimates that come up, and we also have the ministers next Friday. I just want to make sure everybody is aware what the time frame is for this committee, and that we are doing the work for the people that need the urgent assistance today. Not an amendment or not something that comes in here that has absolutely no teeth to it. This is a virtual signaling at its best. Thank you very much. Go ahead, we'll take Anita, back to Shelby, Emanuela.
So on the adjournment and on making sure that the good work of this committee continues, I am 100% for that. What I would like to say is that, to me, this should have been a very simple, very quick motion. to say that something to do with standing up for a woman's right over her own body is political or politicizing, and that it would somehow take time out of this committee is very disappointing to me. I have a family member who had to go in front of 5 male doctors in the 80s to have them tell her that she could not have an abortion. And she almost committed suicide, and she was part of the Morgentaler decision. And this is a close family member of mine. And I grew up knowing that this was something that she fought for me, for our generation, for future generations to have this right. And for anyone in this committee to say that this is politicizing, that women's right to choose, which is a hard-fought right, is somehow politicizing, I find that very, very offensive. It should have been that we could go to a vote instantly, maybe a few of us comment on it, and then all of us support it. That's what should have happened today. It should have taken 5 minutes. Since it's not,
taken 5 minutes so far.
Madam Chair, I have the floor. I'm speaking to the motion to adjourn with the conditions, and I will support the conditions because I do believe that we need to do good work in this committee, but I am very disappointed that this isn't something that this committee would have unanimously supported, as we have had for a generation. We've had these rights as women, and I am very, very offended that this is being considered, this term virtue signaling. I'm sorry, but if standing up for women's rights is virtue signaling, then absolutely, I will do that every day. So I will support that motion because I know we have a lot of good work in this committee, but I would like this to be on the record that this should not have been something that we're still debating, or worse yet, yesterday when we had members out on the lawn of Parliament, members of Parliament who were trying to take away women's rights to choose. So I'm very disappointed, and I wish that it wasn't the case that we still had to battle this in this day and age. Thank you.
Thank you very much. And I just hope it's on the record that it was Karen Vecchio, the chair of the Status of Women, and not a member of the CPC or members of this committee. Those are my words. So I'm hoping that when you take that out, that those are Karen Vecchio said that, because it's very important to me that we do fight for all rights. Absolutely. Anyone who knows me knows that's the case. I have this down, and we're going to Adrian and then Leah. Sorry, I was looking in the room. I'm going to go to Adrian as well. We'll come back to you, Emanuela.
I believe that for the reasons that you raised, Madam Chair, it's not a debate that can be done in a short moment. I agree with the dilatory motion because I also had an amendment to propose to Madam Lambropoulos' motion. We should be able to debate on it, and so I agree with the dilatory motion. Even though it is something important, I also have amendments, and if we're debating on the motion and the amendments, we'll never get out of here. So I think we should take the time to finish what we've got and then move on. But I also would like to raise to the committee that if we come back to this debate, I have an amendment.
Emanuela, and then back to Leah.
Thank you, Madam Chair. I don't think that those accusations were fair. I've never been a partisan member. I've never used any issue for political gain, ever. And so I don't think that's fair. I think that it was the right moment to bring it up because, especially coming out of the situation in Ukraine where hundreds of women have been raped by Russians and have gotten to the Polish border and are not given the right to abort. And they have they are currently not given this option, and they have to live with this trauma and carry it through. Many of them are not being given the option. I think that it's a very the right moment to be bringing it forward, and it's absolutely not political. I stand up for this women's right to choose because I believe that, I was a teacher, and as a teacher, I worked with a lot of young people, many young girls, 12 to 14 years old, who made a mistake and who didn't want to go through with a pregnancy when they found out that they were pregnant. And I supported them because I support young people and I support young women and their ability to fully develop and to become whatever they want and to have that right without having to deal with the consequences of one mistake or of something that might have happened to them against their will. So it's definitely an important conversation. It's definitely one that we should have around this table, status of women. And I don't take away from the important conversations that we've been having on other issues as well. But to say that this isn't the moment to be discussing it when it's being openly debated elsewhere, very close to Canada, and when we see demonstrations happening on the Hill right here in Canada, I think that that's not a really accurate representation of when we should be or not be using or moving this motion. Again, I don't take it well that it's being called a partisan move on my part, because absolutely not. Fighting for women's rights is what we should be doing on this committee. And as my colleague Anita mentioned, this should have been moved quickly, in my view. And I know your views, Madam Chair. I've heard you on this as well, and I know where you stand on this issue. So it's surprising to me that this is even, the way that you've taken it and the way that you've spun it around to make it seem like I'm doing something wrong. Those are my thoughts.
I will take the floor to take the opportunity to say I do apologize to you, Emanuela. I do apologize. This is so not personal to you. I do know the excellent job that you do. I'll pass it over to Leah.
Thank you so much, Madam Chair. I just want to start out by saying, I don't think it's my position to assume intent of anybody in the room. You have done a very outstanding job as chair. I'm really honored to be part of a committee where we actually get things done. Aside, as the Status of Women's Committee, with the wording amendments that could happen, this is it's important that we stand up for the rights of women that are stipulated in the Charter without qualification. We're the only ones doing it in the House of Commons. There's very few of us that are standing up for the rights of women, including a right that's been affirmed through the Supreme Court and part of our Canadian Charter to be able to access a safe and accessible abortion. I certainly was in support of the motion without thought, as it's my obligation as a member of Parliament, without question. So I just want to share that I am surprised. I don't really see this as well as a partisan issue. I do support the motion to adjourn for now, so that, we can continue on with getting the bill through. But I do think this is a critical discussion to have in committee. I don't think this is a discussion that we can sidestep. I think it's something that is critical, potentially even however we need to do it. We need to discuss this as a committee. And just a final thought, that, the most difficult, the most difficult changes come from difficult discussions. And I think because our committee has done such a good job, even in accepting my study, which is a very difficult study for people to go through, that I think that I have faith in the committee members that we can get through some of these discussions that may be difficult for some. And I just want to leave it there, but yeah.
Thank you very much.
Thank you.
There's a few more things. I'm just, once again, I do really appreciate it. And Anita, I know I strongly offended you, and I do apologize that. This is a very, very difficult discussion to have. And I guess the thing is, I just came out of Bill C-233, where we are so passionate about, and I don't mean to cry, but I think the work that we need to get done got done. And so anytime I see things brought up like this, when we're not working together, when we know, and I think everybody in this room knows, we want what's right for women. We do. We all do. That is why Bill C-323, you know what I'm saying, went through like that, because we actually were all working together. My fear is not the Status of Women Committee. My fear is when those people that you do talk of weaponize this. Those are my concerns. Perhaps you've never been a conservative woman like myself who gets yelled at by people that don't understand where I stand. Maybe that's part of the problem. We do need to have a bigger discussion. And, you know, I was very offensive with my language, so I do apologize to you, Anita. Very offensive. And I think it's because I have fought for the same rights that everyone like yourself, Anita, has fought for. I will continue to fight for those rights. I don't trust the people outside of this room to be able to have the adult conversation that we need to have. And so my thing is, the political football is never in this room. It is the moment that we hit outside of this room. It's the moment that becomes the headline, yet people are dying. We know this. And that's my concern here, is that we are starting the ball rolling down a really fast hill where the only people that lose are the women and never anybody else. When I say things aren't going to change, it's because reality, we know things aren't going to change in the next 3 years. And during that 3 years, we should be doing work. That we know that we're in a government where all around that entire chamber, you will have support. And it doesn't matter what side you're on. I will be standing along with those women just like I would today on a vote. I will be standing just as I always have. And my concern is that when we go out of there, that is where the people that are here and here don't want to talk. We know that there's a whole bunch of us here, but we can't have that adult conversation because as a person, a conservative woman, I've had it politicized for, I guess, probably 25 years. And that's the problem. So if I knew that we were doing the right thing, I would be 100% about it. But I can tell you that when I get into that house, just like last Wednesday, I will have to leave because I'm disgusted when I have people yelling at me, just like I yell at them. But it's very hard. Jenna, I see your hand up.
Thank you, Chair. And, you know, I feel compelled just to, first of all, I think acknowledge the success that we've all just witnessed in moving through C-233. And so with that, you know, a thanks to everyone, because I think that that really demonstrates the spirit of the work that we do here at this committee and how well we do it together. And I think it's important to acknowledge that. You know, I thank Emanuela for bringing this motion forward. I do think it's obviously an important discussion. Having said that, and as Leah so eloquently put, hard things are hard. This is a hard topic. This is a hard discussion. I don't think that we're going to be able to resolve or have a fulsome discussion today as perhaps we need to on this particular issue, but I appreciate the brief discussion that we've had. And I think that at this point, I think, you know, the next step is to move to adjourn. I don't think we're going to get any further than that at this point. And we can revisit this at an appropriate time.
Okay. Do I take that as, or do I can continue? So that's the. So that was a dilatory motion there to adjourn. Okay, so I'm going to ask you if you could record a vote.
Ms. Lambropoulos?
Yep.
Ms. Dameff? Yes. Ms. Sidhu?
Yes.
No, we
Ms.
will.
Suds?
Yes.
Sorry, Ms. Suds, I didn't hear you.
Yes.
Yes, okay. Ms. Vandenbeld?
Yes.
Ms. Pereri?
Just confirming we're voting on a motion to adjourn?
Yeah.
Yes.
Ms. Kremp-Newman?
Yes, again, question. We're moving the motion to adjourn, and what happened to the motion that I put forward? Just from a logistical.
Just go to adjournment. That's it. So your motion is non-debatable, or that this one's dilatory. Go.
Okay, thank you.
Madame Bien?
Oui.
Madame Larouche?
Oui.
Ms. Gazan?
Yes.
So 11 yeas.
Go ahead, Pam.
I just want to take a moment on behalf of all of us to thank the chair and thank you for sharing your perspective and thank you for working the way you do across party lines. We've worked together for almost 7 years now, and I think it's really important to recognize the passion and commitment. I know this chair position wasn't something you wanted at the time, but I don't think anyone could do it any better than you do, Karen. And I just wanted on the record that I think I speak for all of us in saying that you bring a really balanced approach to what you do. And if there were more people in politics who treated issues in the way that you do, our country would be a better place. So I just wanted to put that on the record.
Does that come with hugs? Thank you very much, Pam. Thank you. Okay. Can we get adjournment? Okay, ready to adjourn? Okay. All right. The meeting is suspended.